नमस्कार, वेलकम टू इम्पोर्टेंट सुप्रीम कोर्ट जजमेंट सीरीज एपिसोड 6। रोंगटे खड़े हो जाते हैं जब इस तरह की तस्वीर सामने आते हैं। बच्चे, बूढ़े, जवान, औरत, न जाने कितनों की जिंदगी तबाह हो गई बस कुछ ही पल में। माँ के गर्भ में भी एक बच्चा सुरक्षित नहीं रहा। इस दुर्घटना के कई सालों तक नवजात शिशुओं को काफी कठिनाइयों का सामना करना पड़ा। आखिर क्यों हुआ भोपाल गैस ट्रेजेडी? किसकी लापरवाही की अंजाम थी ये? सारे विक्टिम्स को सही कंपेंसेशन मिली क्या? आपके मन में है कई सारे सवाल और इस एजुकेशनल वीडियो के जरिए आपकी सारी सवाल का जवाब देना मेरा रिस्पॉन्सिबिलिटी है। वीडियो के अंत में और एक इंटरेस्टिंग इंफॉर्मेशन आपको बताने वाला हूं, हेंस प्लीज वॉच टिल द एंड। Root of all these started in 1970. There was a company named Union Carbide India Limited that built a pesticide plant in a densely populated area of Bhopal. Who were the owners of this company? Here it is. 51% share was owned by an American company named Union Carbide Corporation and 49% share was with Government of India, government controlled banks and other Indian investors. It means Government of India was also an owner of the company. When plant was being constructed, UCC did not consider the safety feature very seriously. अब जिसका डर था वही हुआ। In 3rd December 1984, water leaked into a tank containing highly poisonous methyl isocyanate. It created a chemical reaction and MIC escaped into atmosphere. Because of airflow, the gas spread into Bhopal quickly and overnight Bhopal became a gas chamber. Thousands of people died, around lakhs and lakhs of people suffered irreparable physical damage. The disaster has such a lasting impact that even today, residents of Bhopal suffer genetic defects, damaged reproductive systems, lungs problem and vision impairedness. The disaster was already so hard to digest. Whatever happened after, that was equally painful. Whose negligence caused all this? What criminal charges were to be initiated? How much compensation to be paid? So much debate happened, but debates remained as debates. The victims got too little. Immediately after this accident, Parliament passed Bhopal Gas Leak Disaster Act 1985. According to this act, listen carefully, only Government of India will have exclusive right to represent and act on behalf of the victims. You must be thinking, it is fine, right? Why poor victims will go through all legal complexity? Better government should represent them and fight for them. But there was a problem. What did I say before? Government of India was also an owner of the company. It means if company caused a disaster, then the government is also responsible for this. Then how you can stand on behalf of a person to whom you have caused damage? People criticized that government is doing this to protect itself. Immediately the act was challenged in court, but court gave judgment that all these citizens are not in a position to secure their right, hence the state must protect and fight for the rights of citizens. In 1985, Indian government claimed $3.3 billion against UCC in New York court. Why New York court? Government of India argued that American court should deal with this litigation because UCC is an American company and America has exported this disastrous technology to India. But American court gave a different judgment. It told that first, most of the documentary evidence like plant's design is in India. Second, in India, many witnesses are available to examine. And the third one, which is very, very important, to take the litigation will be another example of imperialism. We don't want to impose our values, our rules and judgment on a developing nation. India is already a world power and well capable to give justice. And we should not deprive Indian judiciary from this opportunity. Hence, the case regarding Bhopal disaster should be immediately transferred to Indian courts. But the condition is that UCC should submit itself and will abide by any judgment given by Indian courts. Immediately after this judgment, litigation started in Bhopal and company was ordered to pay interim compensation of 350 crore rupees. But company appealed in Madhya Pradesh High Court and High Court reduced the amount to 250 crore rupees. Both the parties were unhappy and the case went to Supreme Court. To dispense speedy justice to the victims, Supreme Court finally ordered UCC to pay $470 million, which is around 750 crore rupees for full and final settlement. It means all civil and criminal cases will be disposed if $470 million will be paid. People were definitely unhappy because government has already given hope for $3 billion compensation and the final amount is 6 times lower than the expected value. and considering the loss and long-term impact, the compensation amount is too less. Hence, judgment was severely criticized and Supreme Court decided to review its own judgment. This reviewed judgment was having two outcomes. One, it was decided that $470 million is a fair compensation, and if compensation amount is inadequate, Government of India will cover the expense. It means Indian taxpayers' money will be used to compensate the inadequate amount. And second, criminal proceedings against UCC officers was revived. In effect of this judgment, later Indian government provided 1265 crore package in 2010 for Bhopal disaster victims, and 7 people were convicted for 2 years. But Mr. Warren Anderson, chairman of the company, did not appear in court and was declared absconder. Before 1984, we had only Air and Water Pollution Act. But after the disaster, Parliament passed Environment Protection Act 1986, Public Liability Insurance Act 1991, National Environment Tribunal Act 1995, Civil Liability for Nuclear Damage Act 2010, etc. and etc. The subject matter of all these acts will be discussed in another video. But the very important point is that under MC Mehta vs Union of India 1986, it was decided that if any enterprise is engaged in harmful production activity, it is his absolute duty to ensure that no one gets harmed, and if anyone is harmed, they have to be compensated. This is called absolute liability. Means a company cannot say we are not careless and we followed all safety protocols, hence we won't pay. Company cannot say like this. This whole story shows how influential multinational companies exploit developing countries. These countries import hazardous technology in spite of absence of environmental law and legal infrastructure to handle the consequence. In the name of economic development, these countries sacrifice their human rights. This is such an ugly side of globalization. Very recently, you might have seen how Johnson & Johnson company gave huge compensation to American patients for faulty hip transplantation, but Indian patients got negligible amount. Let us take another example. In 2010, in Gulf of Mexico, around 5 million barrels of crude oils were leaked to sea. It was a big environmental disaster, and immediately $20 billion fund was raised. We should raise two questions. First, for environmental damage, such a big compensation is possible. Don't you think a disaster which caused so much damage to humanity should have paid more compensation? Second, if the same company would have leaked oil near a developing country, do you think they would have paid such huge compensation? No matter who is behind bar, no matter how much compensation is paid, we cannot eliminate the impact caused by Bhopal tragedy. But one thing we should remember, we cannot press the snooze button and keep on repeating the same mistake. Bhopal Gas tragedy should be a wake-up call for judges, politicians, activists, media, you, me and everyone. We cannot give justice reactively, we should give justice proactively. Because justice delayed is justice denied. I hope the video was insightful. Don't forget to like and subscribe. Yes, I promise to give you an interesting information. Here it is. A very informative movie based on Bhopal disaster is directed by Ravi Kumar, and the movie name is Bhopal, A Prayer for Rain. The link is in description box. I'm Aumkar signing out. Till we meet next time. Bye bye.